All right, welcome back, everybody. This is Cassandra Jenneke. I'll be your instructor for business law at Columbia College. We're going to get started here with a discussion about the topics in Chapter 17, third parties in contracts. So we have now gone through all of the 6 elements of a valid and enforceable contract, all the things that have to be present in order for your contract to be valid and enforceable. The next couple of classes, what we're going to be talking about are the sort of specialty areas that can come up in contracts. So today we'll be talking about third parties and contracts. Then we'll be talking about what performance of contracts looks like and what happens when somebody fails to perform adequately. So we'll talk about performance. And then we'll talk about, as the kind of wrap up to our contract section, the area of damages and what you get when someone doesn't perform like they're supposed to. But today, what we're going to be talking about are specialty contracts that involve people who were not parties to the original agreement. So, typically, the general rule is that only the people who are parties to a contract, the 2 people that entered into the agreement that gave us the contract, can sue to enforce or force performance of the contract. The whole point of entering into a contract is so the parties will perform. But there are certain types of contracts and certain types of circumstances where you can find yourself in a position where you have created a contract that benefits somebody else. And those are third-party beneficiary contracts. You'll see here that I've abbreviated them TPBs. I'm still going to say third-party beneficiaries, but I just didn't want to type it all the way. There are 2 types of those: intended third-party beneficiaries and incidental third-party beneficiaries. Let's talk about them. Intended third-party beneficiaries are kind of exactly what they sound like. So an intended third-party beneficiary is somebody who the parties to the original contract wanted to benefit by virtue of entering into the contract. By doing that, and by having that contractual intention at the formation of the contract, they have conveyed to that third party, intended third party beneficiary, that that person have a cause of action for failure to perform that contract. So they get to sue somebody if somebody fails to perform in that contract. Now, within intentional third-party beneficiaries, there are 2 different types. You have a creditor beneficiary and you have a donee beneficiary. Let's break them both down. The creditor beneficiary is somebody who the promisee intends to discharge their duty to the third party. Okay? So if you have a sale of a business and you are the purchaser of somebody else's business, and that other business owes debts to a bunch of third parties, right? In your purchase of the business contract, you may very well, and absolutely should for clarity if you're buying somebody else's business, list out the creditors that you intend to pay when you buy the business, okay? So there may be some creditors where you're like, hey, seller, you're going to keep that creditor. I'm not paying them off. I'm not going to use that thing that you owe them for, so you get to keep the thing and you have to keep paying it. But if I'm buying a restaurant and the restaurant still has a loan out on all of their refrigerator equipment and I want to keep the refrigerator equipment, I'm going to list out Restaurant Refrigerators R Us as a creditor to whom I intend to continue to pay and to whom I want to assume the debt. So that is a creditor beneficiary. That's someone that you're going to promise to keep paying even after you buy the business, okay? Versus a donee beneficiary. And a donee beneficiary is definitely the third-party beneficiary that I think all of us have a common layman's terms understanding of, because a whole heck of a lot of us either pay for life insurance or are potentially the beneficiaries of somebody else's life insurance. So a donee beneficiary is where you, the promisee, intend to give somebody a benefit and there's no duty there, right? So a great example of that is exactly what I have written here, life insurance, okay? I have a life insurance policy on myself that I pay for, and the beneficiaries are my mom and my brother. If I die, they are the third-party beneficiaries, intended third-party beneficiaries of my life insurance policy. So if I die in a way that is covered by my life insurance policy, my life insurance company owes them a duty to pay whatever the life insurance calls for, right? I think I have like $500,000. So they each get $250,000 upon my death. That is a gift for the family that I'm giving them without expecting anything in return. But I am intending for them to be benefited by that contractual relationship that I have with my life insurance policy and my life insurance carrier. Now, how do you determine whether or not somebody is an intended third-party beneficiary? Well, you have to, one, show an intention, right? 4 corners of the contract, show an intention that you wanted to create a third-party beneficiary. Okay. It has to be shown at the time of formation. It has to be a clear intent to impose a direct obligation to the third party by the agreement itself. In order to find that, you're going to evaluate all the surrounding circumstances of people entering into that contract. You're also going to look at its contents. And there is a really strong presumption that you have to overcome as the third party, because people enter into contracts to benefit themselves and themselves only. That's our presumption. And so it better be real clear in the contract that you, as a party, intended to benefit somebody else and not yourself. Okay? Now, you also have to describe the intended third-party beneficiary in the contract, or describe for you. In my life insurance contract, I have specifically listed my mother and my brother as beneficiaries. However, you don't have to identify them by name. You can identify them by class. So, for example, if I had children, which blissfully I do not, the rest of you that do, you're saints. If I had children, I could also list in my life insurance policy, I could list them out by name, or, you know, if I only have one and I'm planning on having 5, I can just list out the one kid that's alive and any other children. So I identify them by class. You can say biological children, you can say adopted children, you can say stepchildren. You could have no definition on what kind of children. So if you end up actually having adopted children or having stepchildren, that can make things really ugly and not very nice after you die. So feel free to specify. Everyone will appreciate it. But you can identify folks by class. So now, if you name an intended third-party beneficiary in your life insurance policy, say it's your spouse. I'm married to Joe Schmo the Ragman. And then Joe Schmo the Ragman and I fall, as 50% of American couples do, and we get a divorce. I can remove him from my life insurance policy. But that's a modification and a termination of his benefit under that contract. And so you have to look at, when you enter into a third-party beneficiary contract, how and if you can modify or terminate the rights that you have conveyed to an intended third-party beneficiary. Can you do it? Absolutely. But the how has to be followed. So if you define the how within your contract, you just have to do it by the book, so to speak. Sometimes modifications and terminations can happen by operation of law. So bankruptcy is a really good example. Some life insurance policies, as an example, can have cash value that you can borrow against. So if you go bankrupt, that's an asset that you have that would go to your bankruptcy estate that the estate would then use to pay off your debt. I don't have one of those. I don't have a cash value life insurance policy. My life insurance policy only pays out if I die. So when you think about changing who your third-party beneficiaries are, just make sure you do it by the book, because if you don't, you may end up owing your ex-husband or ex-spouse a life insurance policy. Right? Now, the rights that a third-party beneficiary has under a contract are only as great as those that are actually conveyed in the contract. So, for example, in a life insurance policy, if I commit suicide, that is an excluded method of death such that the life insurance policy doesn't have to pay out. So my mom and my brother would not be entitled to payment under the contract because I died by suicide. Moreover, if they had, let's say I don't die by suicide, it's a car accident, I expire. Let's say there's a term in the life insurance policy that says they have to report my death to the life insurance policy within 14 days of my death. If they fail to do that, they may not get anything under the contract because they failed to comply and abide by all of its terms. Okay. So those are all of our intentional third-party beneficiaries. But what would happen if you, as a party to the contract, didn't intend to benefit somebody else, but the contract does, through its performance, benefit somebody else? That, ladies and gentlemen, is an incidental third-party beneficiary. That is a person who benefits from the performance of a contract, but they were not intended to benefit from it, nor were they guaranteed a benefit by the contracting parties. The difference, and this is an important one, between an incidental and an intentional, is that the incidental folks don't get a right to sue for failure to perform or any damages they suffer as a result of the contract being performed or not being performed. So, an example might be, if any of you have ever stayed at a less than savory hotel, right? Place a little dirty, a little dingy, right? Might see a cockroach walking around somewhere, right? Let's say that that hotel, motel, flotel, if you will, has a contract with an exterminator, okay? Exterminator's supposed to come out, they're supposed to do bug work, rodent work, they're supposed to handle all this stuff, and you are a patron at this hotel. And you stay a night at the hotel, you get home, and what did you bring home with you? You probably see where I'm going with this. You bring home the bed bugs. Yeah, gross. And you go to sue the hotel because, hey, hotel, you gave me the bed bugs. Gross. Okay? And I suffered emotional damage because I'd be extremely emotionally damaged about bed bugs. And also health problems, right, associated with that. So if you did that, and you sued the hotel, you might also want to sue the bug company because you just find out that they have been coming, but they haven't been spraying, and they've been taking the money, so they have breached this contract with the hotel. Here's the deal. Do you benefit from not getting bed bugs because they are properly exterminating and trying to prevent them? Yes. Yes, you incidentally benefit by not getting bitten by bugs or bringing home bed bugs. But nothing in that contract said that the reason that they were doing that was to prevent that from happening to you. There was no contractual intention at the formation of that agreement to benefit you. They don't even know you, right? So if a reasonable person, looking at all the surrounding circumstances in the context of the contents of the contract, would have believed that they intended to benefit the guest of that hotel, then you would be an intentional third-party beneficiary. But if there's nothing about you, nowhere in that contract, no mention of guests, no reasons for the contract, you're incidental. Now, does that mean that you don't get to sue somebody? Absolutely not. You get to sue that hotel. You go, girl. Sue them. This is a litigious society we live in. Sue them. But you don't get to sue the bug company for failing to perform on their contract with the flotel. Okay? Now, we also have the concept of assignments. And we like assignments in contracts because at its most basic, we want the economy to be able to move and flow in the easiest and flowiest way possible. We want to eliminate as many roadblocks to change and to growth as we can. And we recognize that assignments or a transfer of contractual rights to a different party will allow for that flow. Now, you'll note that the assignment only transfers rights under a contract. And recall, this harkens all the way back to the beginning, where there is a right, there must be the yin-yang duty, right? Is this right? Right? Yin-yang duty, okay, of somebody to perform or to not perform, as the case is called for, to give you that right. So what in the world does all of that mean, Cassandra? And that's a fair question. So I have created a diagram. So the obligee and the obligor, these boxes at the top here, these are the original parties to the contract. These are the folks who created the original duty and the original right under the contract for payment or for performance, okay? The obligee, the person who wants to give away their rights under the contract, will then enter into a separate assignment contract where they assign away either the right to payment or the right to performance to this new third party assignee, this box at the bottom. So how does this, if at all, change their relationships? Well, that's this piece right here between the obligor and the assignee. The assignment, okay, once that is made, there is a duty by the obligor to pay the assignee or to perform for the assignee. What that does is it gives and transfers the obligation of giving that money, giving that payment, giving that duty, that performance to another person. The obligor is still required to perform. The obligee is still responsible for whatever duties they owe under the original agreement. The assignee is really the person who's benefiting the most because they're getting something for ostensibly, at least in this diagram, nothing. Okay? Now, typically, assignments can take any form in order to be enforceable. This is just another contract. So unless it's a statute of frauds situation, or unless there's a separate state statute or federal statute that requires the assignment be in writing, it's fine to be oral. We know, though, we want everything to be in writing. Yes, yes. Everything should be in writing, okay? If you're going to make an assignment, you got to give notice, right? Because what can happen is the obligor, right, that person that's still obligated to make payments, the person that's still obligated to perform, that person has to know who they have to perform for or who they have to pay. So if you're transferring your right to receive payment, you got to make sure that you tell the obligor, because otherwise they're just going to keep sending their payment to you, the assignor, and then the assignee is not going to get their benefit in the assignment, and the obligor will be failing to perform. Assignments are typically made to raise money or once a business is closing or selling. So if we are assigning away the right to money, okay, right to payment, then you can assign away the right to receive money to someone else. That can also be utilized to assign away a claim or a cause of action against another person. So it may be that your insurance company, during a litigation over a car crash or something like that, may very well say, hey, listen, we're going to pay you out $100 grand right now, assign over your right to sue the other driver to us, and we're going to go after him for whatever we can get out of him, right? So it can be for future money, expected rights, all of those things can go forward. That's also, if you've ever, J.G. Wentworth, 877 cash now, right? Those folks, what you can do for them is you can assign away your right to an annuity payment, right? For upfront cash right now, right? Get your cash now. That's an assignment. Now, you cannot make an assignment that will materially affect or alter the duty or rights of the person who is not involved in the assignment. So the obligor, you can't, by making the assignment, change what they have to do under the original agreement. You can't make it so impossible for them to perform, right? You can't increase the burden of their performance so much that they can no longer perform by the assignment. So you have to keep that in your mind if you're trying to make an assignment. You cannot increase the burden on the person who's not a party to the assignment. Personal services contracts cannot be assigned away. We recognize that if there is a personal services contract that you enter into a personal services contract with somebody because that's the person you want doing the performance. And so if you are assigning away a personal service, so like a butler or a tailor or a beautician, things of that nature, like services that they're giving to you, you can't assign those away. You can't give them to another party. Similarly, with credit transactions, creditors enter into a relationship with you. And they do that because they feel like they've done a sufficient job of figuring out if they can trust you to perform on their agreement. So you can't assign away any rights under a contract, a credit contract, to another person. The assignee will acquire all of your rights under the agreement as the assignor. They stand in exactly your same position with the exception that they do not have an obligation to perform anything, right, under that original agreement. Assignors continue to be bound by the obligations of their original contract. The only way that they are discharged from any contractual duties is through a novation. When we talk about the end of contracts or when we talk about performance, we'll talk more about novations, but that is how you substitute completely a brand new party into an original contract. Assignees are typically not subject to suit, again, because they have no obligation to perform. And most states will have some consumer protection liabilities for those folks because the real person that you should be going after is the assignor and not the assignee, okay? Now, go ahead and read through those. Those are pretty self-explanatory. Every single assignment comes with some unstated warranties, so promises that you are the person who can enter into the assignment, that you have all the rights that you're trying to give away under the assignment. So those are just some implied warranties that go along with assignments in general. And then the yang portion to the yin that is assignments, right, which give away rights under a contract. A DOD, or a delegation of duties, actually transfers the duties of a contracting party to another person who is to perform them. So a super good example of that are subcontractors, right, guys? Like a general contractor will take on a building bid, they'll take on a building project, and then they're going to subcontract out under that agreement a bunch of different stuff, right? The plumbing, the electricity, you're going to hire those types of folks to handle those types of pieces of the project. DODs are allowed when performance is standardized and non-personal, so the contracting parties still remain responsible for those things being performed in a timely manner, performed in the way that was agreed to under the original contract. You, much like an assignment, much like intended versus intentional third-party beneficiaries. You have to show the intention to delegate duties, and under the original contracts, you can prevent or prohibit DODs of the work that you have agreed to if you're the party not delegating. So if the performance involves some personal skills or talents, any judgment or trust issues that you may have, you can prevent, and DODs are in fact prohibited in those circumstances. So for example, if you are, hiring, if I commission somebody to paint a portrait of my dog, right? I'm hiring that artist because I like their work and that's the person that I want to do it and it's the style that I want them to do it in. They don't then get to delegate that duty to their student, right? Unless they have my permission to do so. Okay. That is the end of our conversation about third-party beneficiaries and third parties in contracts. If you have any questions, let me know. Otherwise, I'll see you next time.